Well, let me start with a prayer, and then I'll make an introduction, and then we're going to let Professor Esbeck launch. So, gracious God, thank you for the privilege of being able to be rightly related to you because of Jesus. And the Spirit of God who created the universe also lives inside of us. And because of that, we have identity in Christ. And regardless of our circumstances, Lord, we know that we are a deposit that you have guaranteed and that you take care of us. Lord, I'm reminded of the ways in which information and kingdom building and equipping ourselves, Lord, is not stopped because you allowed for technology to be created and for the ways that we can connect today. Thank you for the ministries that are represented here on the screen as I look out and see the various individuals who have connected here and will watch this also later on the recording. Lord, that we can still become lifelong learners and we're not stopped, and that we get to continue to participate in what you're doing, but we do have to do it in new ways. I thank you for Carl and his ministry through these many years. Continue, Lord, to give him good health and favor and wisdom and a good mind as he does the work, a part of which we will be represented today. We ask these things in Jesus' name, amen. As all of you know, TEI exists for church and campus leaders like yourselves. And so you're not obligated in any way to stay on board with us. If you feel like you get what you need, then you're free to come and go or to step out of this meeting, etc. But I think we're in for a real treat today. I've known Professor Esbeck for, believe it or not, now at least 30 years. When I went to work at McDonald's, the corner of McDonald's coffee was where he would sit in the mornings and do his work before he went over to his classroom at the University of Missouri. And at some point, we came to know who each other was. I was church planting and working as a maintenance man, and I knew him to be a follower of Jesus, and at that time, an elder in his local church, etc. And then we made a connection through a fellow student. I knew of his work with the Christian Legal Society at that point. And it wasn't long until a group of church planters needed him to advise us related to equal access. You remember that, I guess, don't you, Carl?
Oh, yeah, absolutely.
Where we did some really good work. In fact, I always laughed that the Crossing Church is indebted to Barry Watts and Gene Dodson and myself, as well as you, who helped us navigate along with Elton Fay how to get equal access so that that church could be started there at the Rockbridge Senior High School. And so these are the kinds of things that I first knew Carl, but through the years, I've always enjoyed running into him. We both enjoy cheap breakfasts and little hideaway places to have breakfast, either at Knowles on Nifong or eventually Panera. And anyway, I'm giving all away his little secrets, our hiding places, but we like cheap breakfast. So Professor Esbeck has continued through the years to do a variety of things, advise us. He's sort of like the operating system behind the keys or the benefits that we use in technology. Somebody's got to be coding. Somebody's got to be working at a level that most of us can't, because we all experience the benefits of the work of somebody else doing it. And he has been that kind of guy behind the scenes, working hard on a variety of religious liberty issues. And that's both been on a local level as well as at a state level and national level. And so I've always enjoyed our conversations. A more formal introduction is that Carl Esbeck is professor of law at Mizzou for 30 plus years. He retired now from teaching, but he is far from retired. He's still busy writing and doing research while staying active in religious freedom matters here in Missouri and, as I said, nationally. He serves as legal counsel for the National Association of Evangelicals. During this period of sheltering in place, he is writing briefs for the U.S. Supreme Court and the Missouri Supreme Court. And I'll ask him if he would to, in just a moment, to sort of run down some of the cases that he's been involved in, including Hobby Lobby and those kinds of things. From 1999 to 2002, Carl took a leave from Mizzou and was in Washington, D.C. He first served as the director of a religious liberty defense center operated by the Christian Legal Society, and then he served in the administration of George W. Bush in the Department of Justice. His role there was as a special counsel to the Deputy Attorney General, doing First Amendment tasks and working on the president's faith-based initiative. Carl is married to Kathy for 48 years. They have 2 grown sons in St. Louis and Houston and 7 grandchildren. And he is now a mogul of an expert at Zoom in ways that he never imagined possible. So everybody use their reaction button down there and give Carl a hand clap. You know where that's at? Give him a big hand clap. And Carl, I'll turn it over to you to talk to us for a while.
Thank you, Rod. At the law school, of course, student evaluations are anonymous and confidential, and we don't get those evaluations till after we've turned in student grades. So having immediate feedback is a little bit discombobulating. Well, as Rod said, we're going to do 3 blocks, and after each block, we're going to do some Q&A. And the first block is goes into the current docket of the U.S. Supreme Court. The second block is using sort of current religious liberty and pro-life cases as a segue to go back to historical meaning of the Constitution, in particular the First Amendment and the free exercise and establishment clauses. We're going to do that using some current publications. And the third area, coming back to sort of the daily front page, is the sort of issues that COVID-19 has kicked up that are in the nature of church and state. For example, the Paycheck Protection Program, which enables forgivable loans through the Small Business Administration to a number of businesses, including nonprofit businesses, including religious nonprofit businesses, including churches, which are obviously nonprofit businesses. So that's really a revolution in a country where most of us grew up thinking of separation of church and state meant that there would be no funding to religious organizations. So we've traveled quite a distance, and it's pretty fascinating story. So taking up our first topic, I'm going to talk about a total of 6 cases. The first one is a pro-life case, and then there's 5 religious liberty cases. If you don't have a piece of scratch paper near at hand, you might grab one, because when we get into these 5 religious liberty cases, I think if you interact with what I'm saying by putting it down a little bit on paper, it'll help you remember and differentiate these cases. And of course, anytime you get into a case on appeal to the U.S. Supreme Court, it can get pretty subtle and complex, and I'm going to try and make it as simple as possible and completely accessible to the non-lawyer who's keeping current with events, including legal events. So first of all, the pro-life case, and I recognize some of you follow these cases right along, whether you're a lawyer or not. The name of the case is the June Medical Services case. It's been argued already in the U.S. Supreme Court, so it could be decided at any time, though it's expected to come down in June. And it involves a Louisiana statute, one that's very, very similar to one in Missouri, though Missouri statute didn't come about simply by copying what was going on in Louisiana. So the kind of statute is it says that if you're operating a medical facility where there are elective abortions taking place, that the physician who's doing the surgery has to have admitting privileges in a hospital within a 30-mile radius of where the abortion is taking place. In Missouri, the statute's a little bit different. I think it's a 20 or 25-mile radius. So this is being challenged by typically Planned Parenthood. And you know, the question there is it an undue burden on the woman's constitutional right to terminate her pregnancy for any reason? And that particular constitutional right came from the 1973 case, Roe versus Wade. So on the substance, the question is it an undue burden? Obviously, it's a burden, but then all kinds of health and safety regulations take a little bit of effort to comply with, but all to the benefit of the health and safety of the woman who's seeking an abortion. The lower courts, here the lower courts, of course it's federal litigation, but it's the Fifth Circuit Court of Appeals, which embraces Louisiana, Texas, and Mississippi. And so they ruled that this was constitutional, but there was a very, very similar case just 3 years ago that came out of Texas. And the Supreme Court in that Texas case said that this particular regulation was an undue burden, therefore it was unconstitutional. So one of the sort of unusual aspects is that this court is revisiting an issue decided just 3 years ago, which is certainly unusual, but just a little reflection will tell you what has happened in those 3 years, of course, is that the complexion of the court has changed. And we now have Kavanaugh and Gorsuch on the court. So that, of course, is a difference. And they replaced Kennedy and Scalia. Scalia was generally pro-life, but Kennedy was not. So that is a potential difference here. But in any case, the court has decided to review this particular Louisiana legislation. Again, important here in Missouri, because if they sustain the Louisiana statute, then it's a foregone conclusion that the Missouri statute also would be constitutional, and the reverse. If Louisiana is unconstitutional, then the same would be true for the Missouri statute. And that's pretty close to home, because currently in Missouri, the only clinic where abortions take place, where this is an issue, is the clinic here in Columbia, Missouri. So it's pretty close to home, even though it's a faraway case in the US Supreme Court. There's also a sub-issue. Hope this isn't too esoteric, but the court may never reach the merits because Planned Parenthood does not have standing to sue. And that issue comes up in the sense that Planned Parenthood itself is not injured, but they're suing on behalf of the women who are seeking abortions at Planned Parenthood. So the question, normally in American law, you can represent your own interests, but not the interests of others. That's called third-party standing. And there's a few exceptions where the court has allowed third-party standing, but generally it does not. This is a third-party standing case because it's not the health and safety of Planned Parenthood at issue, but rather the health and safety of their clients. So if there's to be a challenge, then one of these women who is seeking an abortion and is burdened by this regulation normally would be the person challenging it. And so if it goes off on lack of standing, the court won't reach the merits, which of course will leave up in the air, so to speak, the constitutionality of the Louisiana statute and necessarily the constitutionality of the Missouri statute. Missouri's in the Eighth Circuit Court of Appeals, and the Eighth Circuit has said so far that the Missouri statute is constitutional. So now I'm going to turn to religious liberty. I've got 5 cases, and this is where I think it'd be helpful if you just made a few notes to yourself as I go through this list of 5 cases.
Prof, before you make that connection, let me ask you if this is relevant or not, and if you want to interact with it this time, or maybe you're coming to it. And that is that I happen to know about the decision that just came down on Monday and the ways in which, I guess, quote unquote, a liberal judge sided with 2 conservatives in what ended up being the minority decision. But a part of the case that I heard made from a podcast was that her and it's not a Christian evangelical podcast, a secular one, but the point that they made was that she did that because she partly was motivated because she argued in that case related to precedents, and she's hoping that she can then say, related to the case that you're talking about, that, hey, precedence has already been set, let's not overturn it. Do you want to speak to that? And is that accurate?
Yeah, no, that is accurate. Rod's referring to the Sixth Amendment case called Ramos, which came down just earlier this week and came down on Monday. And
so from Louisiana, I think.
Yes, Louisiana and Oregon are impacted. The prior law under the Sixth Amendment has been that the Sixth Amendment right, which is a right to a jury trial in a criminal case, the federal rule and is that the jury must be unanimous. But in the past, in applying the Sixth Amendment to the state criminal system, they allowed states, if they wanted to have a criminal conviction for less than a unanimous verdict. It could be 11-1 or 10-2. And so that's the precedent, and that's what Rod is referring to. So the case that came down Monday, Ramos, reversed that decision, and so overruled an old case that was directly in point and had been the law for about 30 years. And when the court overrules precedent, that goes against the normal way in which the court operates. Normally, and lawyers have a legal phrase for it, normally they follow the rule of stare decisis, which is a Latin phrase that simply means thing decided. So it's decided, and we're not going to change what we've decided in the past. But there are compelling reasons to overturn past decisions. So there are some past decisions in these, for example, the pro-life case that we just talked about. There are those in the pro-life community that now that the makeup of the Supreme Court has changed, they want to sort of swing for the fences, so to speak, and go right in and take the 1973 case, Roe versus Wade, challenge that and have that overruled, which would, of course, do away entirely with a woman's right to terminate her pregnancy for any reason. Normally, that's not how the court operates. And it's not unusual, and this is what one of the liberal justices did in this particular Ramos case, said, well, if I was deciding the matter anew, I would decide it this way. But given precedent, I'm going to follow stare decisis and follow the past. And that's a very principled position for a jurist, and that could bear on the pro-life case out of Louisiana that I mentioned. I mentioned there was a Texas case from 3 years ago, and one of the justices might very well say, well, if I'm deciding this case anew, I would say Louisiana was constitutional. But given that Texas precedent, I'm unwilling to overturn it, and I'm going to stay with precedent. So it does absolutely complicate what's going on. And what otherwise would be a sure vote for pro-life, you may lose it simply because as a conservative, they stay with stare decisis. So yeah, good question.
Thank you.
All right, so 5 religious liberty cases. And I just, it's a very small set, so you can't draw too much by way of statistical interest here, but 2 out of 5 cases have to do with funding religious groups. So that's kind of interesting. I certainly grew up in an era where the prospect of government money going directly to a religious groups simply was not even an issue. That was just unconstitutional. 3 out of the 5 cases involve the religious liberty of Roman Catholics, which is kind of interesting. And one of them involves Protestants. But Catholicism has become a major area of religious liberty litigation. And it's also interesting because of the 9 justices, 5 are Catholic. 3 are Jewish, 1 is Protestant. 2 out of the 5 cases involve LGBT, in other words, homosexuality or transgenderism, which is it is the major source of religious liberty litigation today in the lower courts, LGBT. And 3 of the 5 cases involve the free exercise clause or the statutory equivalent of the free exercise clause, which we call the Religious Freedom Restoration Act, a federal statute that protects people from religious burdens imposed by the federal government or federal officials. So, so the first case I'm going to mention is Espinoza versus Montana. This is a free exercise case. It's a funding case. And it's a follow-on case to a case here in Columbia, Missouri. Less than 2 years ago, Trinity Lutheran Church, just a little bit off of Stadium, near the Sinclair station and near Hewlin Lake, for those of you from Columbia, was Trinity Lutheran Church. And the church applied for, and at least initially received, a grant, and then it was taken away, to a grant from the state of Missouri Natural Resources Department. The Natural Resources Department had a program to dispose in an environmentally responsible way old used tires by grinding up these tires and using them to improve playgrounds for children so that the playgrounds were safer. And they gave out grants to nonprofits who had playgrounds who needed improvement in this way. And Trinity Lutheran Church has a child care center as part of their church, child care center during the week, and had a playground, and it was in need of repair. So they applied for and received, and then it was taken away because the state of Missouri has what's called a Blaine Amendment, an amendment passed shortly after the Civil War in a number of states. About 37 states today still have Blaine amendments. Missouri does, and as did Montana, hence this particular case. And the Blaine Amendment essentially says that there can be no state money, directly or indirectly, go to a church or other religious organization, period. No ifs, ands, and buts. All right, so here was money from Department of Natural Resources going to a church. Didn't make any difference what the purpose was. Here it was childhood safety and a responsible way of dealing with old used automobile tires, which I guess are a problem when they go into a landfill. And Trinity Lutheran Church won that case. And so here in Espinoza, which again is Montana, the legislature in Montana passed legislation it was parental choice legislation at the K through 12 level to help parents of private school children to pay for the tuition. Because as you know, our public schools are tuition free, but private schools, you have to pay tuition. And so Espinoza was a single mother with 2 little girls, but she was a Christian, an evangelical Christian, and she in fact did. She was working 2 jobs to carry this off, to enroll her children in a K through 12, or actually an elementary evangelical school. And so she took part in this opportunity where in Montana, pursuant to this legislation, if you were low income, and she certainly qualified, you could apply for a scholarship. They call it a scholarship. And the scholarship from a trust fund would pay the tuition, part or all of the tuition of your child. And the trust fund was created pursuant to Montana state law, where donors would give money to the trust fund in return for a state income tax credit. So you could give money to this trust fund and get a credit dollar for dollar off of your state income tax. All right, so benevolent people gave to the trust fund. That built up the trust fund, and the trust fund was administered, and they would award what they called scholarships, even though these were grade school children, scholarships to private school children, including private religious schools. So somebody sued, said, no, this violates our Blaine Amendment because it results in money indirectly making its way into the coffers of a religious organization, in this case, a religious elementary school. So this particular litigation was in the state court system in Montana. They struck down, they followed the Blaine Amendment and struck down this particular legislation. So there's a conflict there between the Montana courts and the Montana legislature, not unusual. Again, if you're a Missourian, this is relevant because this kind of legislation is proposed every year in our own General Assembly. And one of the arguments is, well, we can't do that in Missouri because we have a Blaine Amendment. All right, so again, there's a little local interest and color into how this case is going to come out. But Ms. Espinoza sued under the Free Exercise Clause, saying, look, you're allowing private school children where their parents choose a secular private school, they can get funding, but if they choose a religious private school, they can't. That's discrimination. And you're discriminating on the basis of religion intentionally, which is true, not maliciously, but intentionally. And that was a violation of the Free Exercise Clause in the Trinity Lutheran case. And so she's saying, well, it's also then a violation of the Free Exercise Clause in this school funding case. Now, of course, it doesn't take too much to say, well, yeah, but there's a difference here, right? A K through 12 religious school is about, among other things, religion. Whereas a playground is not about religion. It's about safety of children when they're using playground equipment. So it's a matter of gradation. So and this case has been argued as well and could be decided any day. And but again, it's expected to come down in June. And based on the oral argument, where we try to read, and it's difficult to try and read how each justice is thinking based upon the questions they ask, or maybe their voting patterns in prior cases, it looks like Ms. Espinoza is going to win this case, albeit by a sharply divided court, probably a 5-4 court.
Now, if you would, Carl, make a connection for me. And again, if you say, hey, Rod, let me, continue, and then I'll wrap it up. But it helps me if I'm a little more deductive with you, meaning you tell me what you're thinking. How are your personal thoughts, given what you know about religious freedom and liberty, are you concerned about that case and its implications? Are you finding yourself encouraged by it? What are the questions that you find yourself asking and wishing? What variables are you concerned we may be missing in our enthusiasm, for instance, in Miss Espinoza's quote unquote rights? How do you distinguish those?
Or our natural empathy with a single mother who's trying to get an education for her little girls that includes some Christian teaching.
And I can either interrupt to help you make these connections and dialogue with you about it, or you can do it yourself. But in each one, I want you to be sure and say, these aren't just the facts, but here's what I'd like for our friends to understand. And again, we're going to be conscious of where the recording goes so that we can have the kind of private links so that it's not public out there. But I would like to I think we'd be helped by your perspectives about where your celebrations are and where your concerns are.
No, and please do go ahead and interrupt. So the legal principle, which I support, but I do have some reservations as you're suggesting. The legal principle is, this is not Montana legislation to fund religion. This is Montana legislation to fund education. And education is a secular enterprise. And these schools are accredited by the state of Montana. So Montana has said, by saying these are accredited schools, that they deliver the education that's required by the state of Montana for an elementary or secondary education. So it's a secular program, just like healthcare is a secular endeavor, or social services or charity is a secular endeavor. Later in this session, not this session, but the last session, we're going to get into economic stimulus is a secular endeavor, okay? So today we have positive government in the sense that whether you support it or not, we don't have just a caretaker government that prevents crimes and prevents one citizen from harming another, and otherwise it's a laissez-faire or a libertarian society. Instead, we have a government that's deeply involved in society, and the way government gets involved is they either regulate it or they fund it. Or sometimes they fund it at the same time that they're regulating it, which is to say they attach strings to their money. So the principle here in Trinity Lutheran and Espinoza, if indeed Ms. Espinoza wins her case, is we have a secular program to which religious groups, along with others, meet the eligibility requirements. So they shouldn't be discriminated against. Now, nobody is forcing these religious schools to take government money, but ought not they be able to choose to take government money? All right, so that's the principle that was followed in Trinity Lutheran and what I think will be followed by the court here in Espinoza. Here's the problem.
And you
the problem
support
is
it.
Strings attached.
Okay, all right.
And in the case of Montana, there are no strings attached, other than to say the scholarship money must go to somebody who's enrolled in an accredited school in this state. They couldn't fund a student who's going to a school in Missouri, for example, okay? Mm-hmm. But strings could be attached, and we're going to get into that a little bit much later when we get into the federal program called the Paycheck Protection Program.
Right.
There are strings attached like okay, if you take this money, you don't have to take our money, but if you take this money, then you can't discriminate in employment, or you can't discriminate into who is served, or you can't discriminate in your particular educational program. And some of that is quite innocuous. We don't discriminate on the basis of race or national origin as to the students we enroll or how we treat them and so on. But some of it is going to become problematic, at least for some religious schools. For example, do they have to admit students of two parents in a same-sex marriage? What kind of implications would that have? And they might have reservations in doing so, and so on. Or they might not want to admit a child who says that they're transgendering from female to male, even though they're 10 years old, and so on and so on. You can kind of see the problems. Or, oh, we're happy to enroll those students, but now we have to provide them services, and we have to provide them, well, of course, maybe overworked is the restroom issue. Again, if we're talking about gender identity and so on and so on. So strings can get attached. One argument is, but it's not resolved, is you can't attach strings that would otherwise violate the religious liberty of the school. But others say, no, 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 we're not forcing this money on you. You're taking the money is a matter of consent, but if you consent to take the money, you get the strings, and that's an unresolved issue, and so we do worry about that.
That was very helpful.
One way of solving the unresolved issue is, well, if that unresolved issue comes down the wrong way, then going forward, we just stop taking that money, but for now, no strings, we have no problem with taking the money, and if that helps one of our single parents not have to de-enroll her little girls and send them to public school, we're happy to help have her take the scholarship funds.
So therefore, you generally supported the Trinity Lutheran case. You generally are hoping that Espinoza will be overturned. And yet at the same time, you're always keeping in mind, what are the strings attached that we may not be aware of? And then that begs the question, which again, we don't have to address now, but it begs the question, yeah, but how might strings later get attached? Because that's a question that many who are watching will be asking when we come to part 3, if we accept this this PPE stimulus. Okay.
Yep.
Got
yep.
it.
You got it.
That was helpful.
All right. Second religious liberty case, Little Sisters of the Poor. This case will be argued May 6th, so coming up pretty close. And the Supreme Court announced a year ago, because of COVID-19, nobody in the courtroom, not even the lawyers arguing the case, they're going to argue it by, video electronic means. And the justices will not be on the bench. Nonetheless, it'll be a setup. I don't know if they're using Zoom exactly, but it'll be a setup like this. So apparently that's going to be, all of us who are interested can tap into that and watch it live, so to speak, in the comfort of our offices back at home. So this is an issue that many of you are familiar with. This is Affordable Care Act. This is an issue big time during the Obama administration. So Affordable Care Act, which set up as the minimum healthcare policy that you could purchase under the Affordable Care Act, involved a very, very elaborate array of contraception devices and products if you were a female employee. So I think there were 33 different contraception devices and products and drugs that an employer minimally had to make available to female employees, not just female employees, but male employees. If it was a healthcare policy for the male's family, then his wife would have available to her this full array of contraception devices and drugs. And and this was objectionable to Catholics because, as you know, Catholics object to all forms of artificial contraception. And it was objectionable, rather famously, to Protestants because 3 of the 33 acted sometimes, not always, but frequently enough, as abortifacients, which is to say, if the woman used the device, an IUD of a certain sort, copper, or if she took a certain kind of drug, it acted to take the product of conception, which in a conservative Protestant view is a human being now, and it prevented the product of conception from implanting in the uterus and, of course, creating a placenta and so on. So it, from Protestants who don't object to artificial contraception, but they did object to killing a human being or the product of conception. So that led to the Hobby Lobby case, as you know, came out 4.5 years ago. Hobby Lobby won. And there was, I think, 150 different religious groups, Protestant and Catholic, around the United States suing. As disclosure, I represented some of those Protestant groups, some Protestant colleges that were objecting to that. And there were a number of Catholic groups. But Hobby Lobby was a for-profit corporation, and it won under a federal statute, which I mentioned a little bit ago, the Religious Freedom Restoration Act. And that restrains the federal government putting substantial burdens on people's religious faith. So in the Hobby Lobby case, it was the Green family. I think there were 2 or 3 siblings which owned in totality the Hobby Lobby chain of stores. And they were conservative, or are actually, not past tense, they are conservative Protestants. And so they objected to providing these 3 devices and drugs that acted as abortifacients. They didn't object to their providing the other 30. But nonetheless, the Obama administration vigorously fought this, but ultimately lost in the Hobby Lobby case. Well, the difference between Hobby Lobby and Little Sisters of the Poor is that they're a nonprofit. And so when there was a changeover of administration, the new administration in 2016 said, well, we're changing the regulation. We're going to exempt all these religious groups, such as Little Sisters of the Poor, which the Obama administration refused to give religious exemptions. Here, the new administration, the Trump administration, said, well, we are going to give them exemptions. The lawsuits are over, done. They're mooted out. And so me and my clients, we celebrated, put in an application for attorney's fees and took our money and went home. We required a consent judgment against the federal government just to make sure that they didn't later renege. Well, some religious groups, some states, in this case, Pennsylvania, objected to the Trump administration religious exemption. And they said that religious exemption goes too far. It's not authorized by the Affordable Care Act. And you did it contrary to the Administrative Procedure Act. And it exceeds the Religious Freedom Restoration Statute. So they had all kinds of reasons why the Trump administration couldn't do that. So now it's in front of the Supreme Court. And the case that they're hearing is, and there's, of course, a little bit of irony in this, it's the Little Sisters of the Poor, which, of course, is Catholic, as you might infer. And the Affordable Care Act requires that this order of nuns, which I think this order was created 200 years ago in Europe, and this order of nuns who serves poor people has to have healthcare policies with the full 133 different contraception devices, and of course these are Catholic nuns. So so it's an interesting case, and the wide assumption is, and I share this assumption, is that the Supreme Court has taken this case up. Incredibly enough, the Third Circuit Court of Appeals ruled against the Little Sisters in some rather bizarre reasoning, which I'll state in a minute, but it's widely believed that the Supreme Court is hearing this case to rule in favor of the Little Sisters of the Poor, saying that they have a federal right under the Religious Freedom Restoration Act, the same act under which Hobby Lobby got victory, that they don't have to provide contraceptions under the Affordable Care Act if there's a substantial burden on their religion. And there's really no issue in the case. These are Catholics, so everyone agrees that Catholic doctrine is against artificial contraception devices.
Carl, is it safe to assume that the reason that the Supreme Court was motivated to hear it is in order to ensure that the Hobby Lobby decision continues? In other words, they didn't like the decision and therefore they were willing to hear it? Is that a safe assumption?
Yes, but by half, it's protecting the ruling in Hobby Lobby, which was a 5-4 case, so a narrow victory for Hobby Lobby. And this might be going a little too far afield, but it was a ruling where progressives were shocked that they lost, and they were very unhappy. And their reaction, for the reason I'll state, their reaction is, then we've got to repeal the Religious Freedom Restoration Act, because that now is such an aggressive protection of free exercise of religion that it's going to mean that even claims for non-discrimination by LGBT will lose in the face of the Religious Freedom Restoration Act. And that really has upset the progressive half of America.
And just give us a Reader's Digest edition, kind of a Wikipedia from Carl related to the Religious Freedom Restoration Act. I vaguely know what you're talking about, but remind me of which administration, et cetera, got that done. And your work on it. You participated in that, I assume.
Well, there were 2 federal statutes passed as a result of a Supreme Court case decided in 1990. Most of my students weren't even born in 1990, but it doesn't sound very long ago to me. And this is called the Smith case. The Smith case was an interpretation of the Free Exercise Clause, and it gutted the clause. Before the Smith case, this Free Exercise Clause gave fairly robust protection to religion. After it, not so much. So Congress was so upset with what the Supreme Court did that they, in 1990, just 3 years later, they passed the Religious Freedom Restoration Act. And by statute, they reimposed the vigorous protection of the Free Exercise Clause. And then a few years later, they passed a statute. I should say, I've said this before, but let me say it again. The Religious Freedom Restoration Act only applies to the federal government, not state and local governments. So a few years later, they passed Congress passed another statute saying, we're going to apply the same rigorous standard for free exercise as to state and local governments when it comes to zoning and other land use controls, and how people who are incarcerated in prisons and jails are treated, because Congress made a finding that those who sought to exercise their religion while in prison or against zoning authorities were being constantly discriminated against by state and local governments.
Right.
So that statute, which I was deeply involved in, because that's when I was back out in Washington, that got passed by Congress.
Gotcha.
All right, so, all right, let's let go of that one.
Hey, before you go there, let me ask you a quick question. Just checking the time. 12:23. In order to cover the other two, do you want to go through all five of them, or do you want to pick one of them, or just you do what you want to do? But I'm asking.
Let me cover them both, but quickly.
Okay.
All right.
And then we'll open it up for questions. Sure.
All right. So there's the Fulton case, Fulton versus City of Philadelphia. It'll be argued about next November 1st. The oral argument has not yet been granted. And this is an LGBT case. And it involves the free exercise clause. And the objective of Fulton, and the reason the court granted review in Fulton, is to reconsider the Smith case and whether Smith should be overruled. And so the issue in the Fulton case, City of Philadelphia has more children in foster care than they can handle. And a number of religious social service providers serve these foster kids and help find homes to place foster children so that they're not institutionalized in 24-hour care facilities. And churches are particularly good at finding homes because there are moms and dads in churches, and so churches are pretty good at helping to place foster children.
Yeah.
And so this one involves Catholic Social Services, and they were finding marital homes to place foster children, but they would not place children in same-sex marriage homes for reasons of Catholic doctrine. And so Philadelphia said, well, if you're going to behave like that, well, we're going to cut you off. We're going to cut you off from all the funding. And so Catholic Social Services sued and said, well, this violates our free exercise clause rights. So that's a big case. And the last, well, I got two more cases. Our Lady of Guadalupe, which will be argued May 11th, again by Zoom or similar platform. And this involves the Establishment Clause and a doctrine called church autonomy. Back when churches were established, churches were heavily regulated, especially the established church. And one of the things the government did was they picked who could be a cleric, who got promoted as a cleric, who got dismissed or fired or disciplined as a cleric. All of that was a governmental function. So a couple of years ago, in a Lutheran church case out of Michigan, 2005, so not so long ago, or sorry, 2015, not so long ago, the Michigan, under its non-discrimination laws, tried to tell the state of Michigan who they could hire and fire as a minister under the guise of non-discrimination against your employees. So
Wow.
In that Michigan case, the Supreme Court said, no. Churches in America are not established. Churches in America, because we have an anti-establishment clause, we don't tell churches who they can hire as their pastor, priest, or rabbi, and so on and so on. So you get the idea. This is a church autonomy idea. Well, in the Our Lady of Guadalupe case, it's a K through 12 Catholic school. And the state of California is trying to tell that school who they can hire and fire as teachers in their grade schools. And the Catholic schools are saying, no, our teachers are in part ministers to the children. That's why parents pay all the tuition that they do to send their children to a religious school, because they want a religious education. And if that religious education is to be delivered, it's going to be delivered through the classroom teachers, just like most education is delivered through classroom teachers. So the Ninth Circuit, which is way out west, including California and Washington and Oregon, so yeah, that's the left coast. And as you might imagine, they ruled against the Catholics, and so this case is
Wow.
is a K through 12 religious school teacher, a minister, conveying religious teaching to children or not, and that's the issue. The other case, the last case, which has been argued and could be decided at any time, is Bostock. And this is not a constitutional case. It's rather a statutory interpretation case. The Civil Rights Act of 1964, as you know, prohibits discrimination as to certain protected classes, race, national origin, religion, so on, but also sex. And some very, very progressive courts, federal and state, interpreted this statute, which has been around since 1964, which is before some on this session have been born. And so that's a long time. And but they interpreted sex to include LGBT. And the particular discrimination that was going on was on the basis of sexual orientation, or it's actually three cases consolidated. In one case, gender identity. So it's a matter of statutory interpretation. When Congress prohibited sex discrimination, did they mean also sexual orientation and gender identity? And initially it was thought that this would be an easy win, that sex means sex, male or female. It doesn't mean sexual orientation or gender identity. But there's a good deal of, I guess you'd say, educated speculation that we might very well lose this case by one of the conservative judges joining with the four progressive judges.
And what is it guessed will be his motivation for doing so?
Well, he just, and this is, the speculation is as to Justice Gorsuch, that he honestly believes that interpreting the word sex includes sexual orientation and gender identity.
Okay, gotcha. Interesting. When is that going to come up?
It could come down anytime, but certainly by the end of June.
So Bostock, B-O-S-T-O-C-K?
Yes, B-O-S-T-O-C-K. Yeah.
Okay.
Bostock versus Clayton.
Tell us a resource, an easily accessible resource like the one that you're giving us today, to when these decisions come down. Where do you turn? Or where would you recommend I turn to?
When they come down?
Yeah.
I would go to SCOTUS blog. So in all caps, SCOTUS, which is Supreme Court of the United States, the acronym, right. Supreme Court of the United States, .com, I guess, or .blog, I'm not sure. Just if you Google SCOTUS, I would say SCOTUS blog, SCOTUS.blog, and they'll have the opinion there for you. And so you can just click on it, but then they'll also have tightly written essays, usually pro or con, people criticizing the opinion, people praising the opinion. And
yeah, very good.
That would be the place to go. SCOTUS blog, yeah.
Got it. All right, thank you.
How are we doing? This is where the first third is done. We were going to do Q&A.
Let's just see if there's an individual or two that would like to ask, and then you keep your answers short. So I'm going to allow the participants to unmute themselves. So does somebody have a pressing question or comment before we move on? You're open now. So you can either press your space bar and talk if you're on a PC, or just unmute yourself there. Question? Anyone? Am I correct in thinking that you can unmute yourself? I think I did that.
I see a lot of little red men with a slash through them.
Yeah, I do too. Anyone?
I don't think I'm muted.
Okay, go ahead. Anyone? Jason, did you have a question?
I was wondering, I know how I was saying you could put provisions, like you could attach strings to some of the funding. And I was just wondering if anyone has tried to push it the other way and made it more of a conservative string, where if you teach, certain things that are more liberal, that you don't receive funding. Have they tried to push it in that direction to kind of get rid of that type of manipulation?
Good question. Carl? Oh, I'm sorry. I think that may have been me. Let me make sure that I have, yep, I got to unmute. Sorry, Prof. You're unmuted now. My regrets.
In a couple of instances, most famously North Carolina, they did try to attach to some funding that gender unified restrooms would not be required. And, but rather schools had to apply just traditional restrooms and locker rooms, like males for males and females for females and so on. And there was a lot of litigation in North Carolina over that. Then there was a change in the governor's office, and the new governor did away with it. So the issue ultimately sort of mooted out. But by and large, while it's certainly feasible to have a conservative string attached, it hasn't been the pattern. Strings, of course, are attached by either the legislature or increasingly by regulators in the executive branch attaching strings, because increasingly law is made by executive regulation rather than by the legislative branch.
Very good.
Carl,
All right,
Carl, let's assume the Supreme Court does say that sex includes sexual orientation and gender identity. What's the practical effect of that?
Well, it means that the practical effect is that the Civil Rights Act of 1964, Title VII, which prohibits sex discrimination, now also, as to employers, prohibits discrimination on the basis of sexual orientation and gender identity. That applies to all employers in the United States if you have 15 or more employees. And so that would include quite a lot of small businesses, including law firms, including religious social service providers and religious K through 12 schools, and it certainly would include every religious college or university.
Yeah.
And the same reasoning then, which is Title VII, would also apply to Title IX. Title IX, of course, prohibits sex discrimination at every education institution, not just in athletics, where we originally used to think of Title IX, but you know, how co-eds are treated on campus, sexual assaults, and so on and so on. And suddenly that's not just based on male, female, but it's sexual orientation, gender identity, and et cetera.
Very good. Thank
So it's
you.
pretty profound.
Good question. Good interaction. Let's go to part two.
All right. Well, so now a little bit of segue, because I want to make the case that this is highly relevant to what you do on a daily basis. For a number of years, the U.S. Supreme Court and the federal judiciary in general has been urged to interpret the Constitution more and more based upon what at the time was called original intent. Of course, this is a subject of politics. It's a subject of federal judicial appointments, et cetera, and so on. And the new phrase is original public meaning, that the Constitution, which was, of course, written in 1787, ratified 1789, the Bill of Rights added 2 years later. When it was written and ratified, the people who did it had and publicly stated, here's what it means. It was heavily debated, sharply debated, divisive, but ultimately passed, both as to the Bill of Rights and the Constitution proper. In fact, there were 12 amendments and only 10 passed. So it was a heated debate. And so we know out of those debates what they thought those words meant, and the program, if you will, is that's what judges ought to follow. They ought not to make it up based upon their personal preferences or new developments in philosophical thinking or moral philosophy or whatever. That our Constitution is a document that struck a deal. And that's the deal, unless, of course, you pass an amendment to the Constitution. Well, the Supreme Court is ever so slowly buying into original public meaning, and in particular, in the two religion clauses of the First Amendment, which we call the Establishment Clause. It's really anti-establishment, and the Free Exercise Clause. So, for example, in a case just decided less than a year ago, the American Legion case, you'll remember reading in the paper or watching on television, there was a World War I war memorial in Maryland, owned and maintained by the state of Maryland. And it was put up in 1925. They had to raise the money, which took a few years, but ultimately they completed it and dedicated it in 1925 to the Great War, and 49 men who were killed in a particular county in Maryland in what we call World War I. Well, the cross, which is 40 feet high, the major feature of the war memorial is a cross, a Latin cross. And above ground level, it's 40 feet high. So the American Humanist Association, which has as part of its program or agenda, is to separate church and state vigorously or sharply. And so they sued, saying that this violated the Establishment Clause, and the lower court agreed with them. So it went to the U.S. Supreme Court. U.S. Supreme Court reversed. They said that the memorial, including the Latin cross, and that while the Latin cross was the largest feature, there were features to the war memorial which were clearly secular. For example, there was a brass plate with the name of each man who was killed and so on, and it had words like valor, courage, things of that sort, which are hardly exclusively religious in character. So, the basis for upholding this was they went back to history. The majority did, and they looked at similar use of religious symbology in our history, and they said, well, you know, if that was okay in 1789 or 1791, we infer then that it's okay today. In another case, just a few years older, City of Greece in New York, a small town in upstate New York, the city council meeting, which met once a month, unless there was an extraordinary session, but they started it with prayer. And they would bring in local pastors and priests as volunteers, No one was forced to do this, and they would offer a prayer. And they would just leave it up to the pastor or priest to say what he wanted in the prayer. So some had Christian prayers, some did not. Some had prayers that were sort of, well, they were certainly theistic, but maybe from a Christian standpoint were a little bit watered down or something, but nonetheless theistic, honoring God, but not necessarily prayer in Jesus' name or things of that sort. Well, of course, so there's a lawsuit over this. This violated separation of church and state. And again, it was upheld by a majority of the court, sharply divided, that going back to history. So suddenly the history, and I mentioned earlier the Fulton case, that's the city of Philadelphia case, which we're trying to overrule the Smith case. That's the foster care case. We're arguing history, that the Smith case should be overruled because it's not consistent with the history of the Free Exercise Clause 1789, 1791, and so on. That's the kind of argument. And the court, a majority of the court, we hope, although it's not certain that we have a majority of the court would entertain that kind of way of interpreting the Constitution. All right, so now the federal government never had an established church or established religion. So therefore, there never was a federal disestablishment. So if we're to learn what a disestablishment is in the American mind at the relevant historical period, and of course, what disestablishment means is what the Establishment Clause means in reverse, the Establishment Clause in the First Amendment, which again, Congress shall make no law respecting an establishment of religion. That's the first phrase in our First Amendment. So what does establishment mean? And then it says, nor prohibiting the free exercise of religion. What does the two words free exercise mean? Well, you have to go back to not a federal history, because there is no federal history, but rather the establishments that we had were in the states. And therefore, when we went through a disestablishment, we didn't go through one disestablishment, we went through several disestablishments, state by state by state. So you need to go back and look at that historical period. What did the state establishments look like? And then they went through a disestablishment. Why did they go through a disestablishment? And they went through a process of adopting state constitutions that protected religious liberty. What did they think they were protecting when they protected religious liberty in the state constitution? What did they mean by religious liberty? What were the qualifications on religious liberty and so on? Because obviously it doesn't mean sort of the classic case that we're not protecting child sacrifice to a cruel deity. You may call that religious, but that's not the kind of free exercise, of course, that has ever been protected in the United States. So the vehicle for doing that, then, that's this book, which I was a co-editor of, because in American legal scholarship, no one had ever pulled together under one cover these stories of what the state establishments looked like. And of course, those establishments were not by states, but by colonies. British colonies in North America. And of the original 13 states, 11 of them had established religions. The Congregational Church was established mostly in New England. Congregational Church is the Church of the Puritans. And elsewhere, the Church of England was established. And just 2 states never had establishments, but one of those 2 states, Pennsylvania, they never had establishments because of William Penn and the Quakers, Quakers didn't believe in an established church, but the laws of the colony of Pennsylvania greatly and in many respects favored Catholics, or sorry, favored Quakers. And so they overtly favored Quakers, passed laws which favored Quaker doctrinal positions and so on, even though Quakerism was not formally established. So what this book does is there's 21 chapters. The first chapter has two purposes. It's introductory, sort of frames what the book is about, and the sort of marching orders that we gave our chapter authors, because we had 20 authors. So chapters 2 through 21, they each have a different author. And the authors, just a little over half the authors were historians at colleges and universities throughout the United States, and they had a record of already publishing on the particular colony, now state, that we wanted them to write on. And about a third of our authors were in the discipline of political science, but also at colleges and universities. And but they were political science faculty who are interested in history, including the history of the founding period. And then the balance were law professors. Some of us law professors do American legal history, and so the rest of the authors were law professors. So those were the people, and then myself, and I had a co-author who was a historian. He's presently at Samford University, which is in Birmingham. And he's chairman of the history department at Samford University. All right, so chapter 1 sort of sets up what kind of marching orders we gave our authors, and we gave them 18 months to research and write their chapter and submit their first drafts. And then we went through 5, 6, 7, in some cases, 8 different drafts, passing them back and forth until we finally had where my co-editor and I had a work product that was ready to be published, and it's published by the University of Missouri Press. And but the other half of chapter 1 is findings. So after we had all of the chapters in, pretty much in their final form, we were still polishing with some of our authors, my co-editor and I begin to distill, you know, what commonalities, what sort of things, principles that we can interpolate out of this work product, of things that were true in many states or all states or a few states and so on.
Yeah.
So, just a couple of those findings. And going into this, we already were familiar enough with what was there that we knew that there were 2 sort of conventional wisdoms that were but widely believed to be true. And because many of us, including me, except for law school, were products of public education. And public education modern public education has a particular point of view when these things are taught. So one point of view, which turned out to be false, is that that religious liberty in America, which was a wonderful achievement, and totally broke with the European models, where all the European models had established state churches. And we broke with them, which is a wonderful achievement. But we broke with them. The conventional wisdom is, well, a few of the colonies come states were kind of experimenting with religious liberty, but once the federal government adopted the First Amendment, that became the model for everybody else. And pretty much it was just a few years thereafter that all the rest of the states, and indeed all right-thinking Americans, sort of fell in line. Religious liberty is pretty much the embodiment of the First Amendment and the product thereof. That turned out to be, and of course we didn't tell our chapter authors what we were thinking, so that they would go find what we were already thinking. But in fact, as the chapters came back, they confirmed what my co-editor and I had kept to ourselves, or kept close to the chest. The American First Amendment, the federal First Amendment, had an impact in not a single state, not one. The disestablishment and implementation of religious liberty, American style, took place with absolutely no influence whatsoever of the federal First Amendment. They went about finding and embodying and developing their notion of disestablishment and religious liberty for reasons other than the federal Constitution. So that was
so what you're
pretty
saying
startling.
So what you're saying is that it confirmed that it was state-driven, not federal government-driven. In some respects, the federal government and the First Amendment was reflecting what was already happening in the states. Did I get it?
Yes,
Okay.
You got it. I would just add this. There were state disestablishment. The federal First Amendment was written in 1789 and ratified by 1791. Some of the state disestablishments took place before that. Some of them took place after that. But none of them were influenced by the federal First Amendment.
Yeah.
So you're right. You said something that I didn't say, but it's correct. When Congress sat down and wrote the First Amendment, they were men who came, they were all men, sorry ladies. They were men who came from where? From states. Mm-hmm. Some of those states had gone through a disestablishment, many others had not yet. But what they thought an establishment was the establishment from their home state. And what religious liberty meant to them is what religious liberty meant back in their home state. Of course, now they're, from all these states, they're together. There were 11 states that ratified the Constitution. 2 did not till later. Rhode Island and North Carolina did not till later. So in the first Congress that wrote the Bill of Rights, including the First Amendment, there were just 11 states, 22 senators, that's all. And they were sitting in an upper room in New York City. There was no capital called Washington, D.C. That didn't exist yet. So the House sat on the first floor. Of course, there were more representatives, and the 22 senators were on the second floor. But what those men thought was they were products of their home states. So if you want to know what they meant originally, when they wrote the word establishment, or when they used the words free exercise, you got to go to the states. So the other sort of conventional wisdom that turned out not to be true is, and see if you weren't taught this in high school social studies or high school government. I was, that in America, religious liberty came about through pragmatism. That is to say, in America, there were lots and lots of different religions. No religion was in the majority. And now Americans wanted religious liberty. They wanted it bad, but they just wanted it for themselves, nobody else. But they were a minority. They were all minorities in a religious sense. So they figured out that if they were to get religious liberty for their minority denomination or Catholicism, then they had to, begrudgingly, grant religious liberty to everybody else if they wanted it too. And so that's how we got religious liberty. It wasn't principle. It was pragmatism, all right? False, completely false.
Wow.
There is no basis for that in the chapters that were provided to us by the historians, political scientists, and so on. Just a couple of other findings, because I want to be conscious to our time and also honor some Q&A. I was taught that, hey, if you were to name a name that brought about religious liberty in America, what would that name be? This is a real easy one for Missourians. I didn't grow up in Missouri, but boy, I've lived here longer than I've lived anywhere else. And I know that this gentleman, one of the founding fathers, pervades Missouri thinking. In fact, we even named our capital after him, Thomas Jefferson.
Yeah.
Well, it turns out that the state disestablishments and religious liberty, the extent to which they relied upon Jefferson and his writings, almost zero. Almost zero. Now, to be sure, Jefferson was impactful in Virginia, as you would think, right? Home state. And so where was he when all these other disestablishments were going on in sister states and the First Amendment was being debated and ultimately ratified 1789, 1791? He was in France. He was our minister to France, what they called minister to France. We would say diplomat to France, to the Republic of France. And, communication, it took 3 weeks for a letter by boat to make it from France to the United States. That's 3 if you didn't hit a storm. Then it was 5 weeks or 6 weeks or whatever. So yes, he was communicating and expressing his opinions, but in private correspondence. Not, please, the pro tem of the Senate, won't you read this to the senators so they can be enlightened by me, Thomas Jefferson, as to what I think. And no doubt they'll try to do what I think because I'm such an influential founding father. Never happened. He did communicate with, on these issues, only with James Madison, who was in the House of Representatives and certainly influential. And he is a major player, James Madison, in the matter of religious liberty, both in Virginia proper and at the federal level. But James Madison, not Thomas Jefferson. And yes, Jefferson influenced religious liberty at the federal level when he was our 3rd president. He, of course, served for 8 years. And while he did a lot of things, and one of which was religious liberty, that's federal religious liberty, not state religious liberty. So again, Jefferson had almost no influence on religious liberty at the state level. Now, Rhode Island did take a Virginia statute, which Jefferson originally authored, and then it was amended by Madison in order that it could be passed, because it was so radical, Madison had to water it down so it would be passed in Virginia. And Rhode Island, when they were doing something on religious liberty, they did consult that Jefferson statute as it was passed in Virginia. They further watered it down because it was too radical for Rhode Island, and then they adopted it in Rhode Island. That's the only evidence of Jefferson's impact on state religious liberty outside of Virginia. All right, so you have to differentiate. Yes, he was an influence, along with many others, on religious liberty at the federal level. But again, during the first Congress, when the First Amendment was debated and written, Jefferson's off in France. Okay, and they were written in August and September of 1789. He couldn't possibly react and have input in what was going on in New York City.
Now, Carl, I know you're doing something, and again, I'll follow your lead on this, but you're doing something with that information to say that if original intent is going to guide us, this is informative, because this is not simply a good idea of a government policy, this is deeply rooted in the masses, in the state government. But help me make those. What are you doing currently with what you are saying?
Well, okay. At the federal First Amendment level, I'm saying if you want to really know historically, when they use the word establishment, respecting an establishment of religion, when they use that phrase, if you really want to know what that means, you have to look at the state disestablishments.
Yeah.
So you've got to look state by state.
Right.
And prohibiting free exercise. If you want to know what the two words free exercise means, again, you've got to look at what did it mean to freely exercise religion at the state level. That's what those men brought with them to New York City when they wrote and debated and wrote this amendment. So to know what those words mean historically, you've got to go state by state.
So a part of what you're saying is that when we're discussing these religious freedom issues, you're always mindful, again, of a variable that you're introducing me to, which is this tension to be very aware and vocal and et cetera about this boundaries of the federal government and their respect for the state government.
Yes.
And,
yes.
And religious liberty has to exist at a state level. Disestablishment originally was at a state level, and then it's reflected at a federal level. And that gets flip-flopped too often in the minds of the public currently. And, and that's a concern.
Yes. Yes.
Got it.
Yeah.
Got it. Thank you.
And, you know, here we are in the 21st century. We have a very active federal government. And that's just being demonstrated here with the COVID-19 matter.
Right.
A very aggressive, active federal government. Back then, it was completely different. Your government, the government that really affected you was your state government. The federal government rarely touched the life of men and women. Rarely. Very, very rarely.
Yeah.
The federal government was pretty much foreign relations, military defense, and Indian affairs, and taking care of things out in the territory, because the territories, of course, didn't have their own government, so the federal government administered the territories. So that's
good.
Those are things that didn't touch the day-to-day lives of citizens in America. I want to just circle back to, TEI in particular. People who care about TEI would want to know this. Finding number 4 is contrary to religious liberty, and in particular disestablishment, being aggressively advanced was not out of pragmatism. It was out of religious zeal. The people who worked the hardest petitioned the government, said, I'm going to vote according to this principle. They were Protestant dissenters who were growing very, very rapidly because of religious freedom. The state churches were diminishing in size, and the Protestant dissenters, that is to say, you dissented from the state church, they were growing very, very rapidly under what's called the Second Great Awakening. And they were very, very numerous, very, very vocal, enjoying their new liberties, having won the revolution. And they believed in their biblical exegesis, they believed that a state church was corrupt, was corrupting the gospel. And they went to verses like Christ before Pilate saying, my kingdom is not of this world.
Right.
And they went to render under Caesar and render under God. And so that the church, to be pure and about the gospel work, must be free of government. And that's how they interpreted the Bible. Now, whether you agree with that interpretation or not, or their extreme feelings or not, they were driven by how they understood Christianity. And that was their motivation. And they weren't just Baptists, though Baptists were part of it. If you grew up Baptist, you got this at Sunday school in Baptist churches. But it wasn't just the Baptists. It was Presbyterians, especially the Presbyterians from Scotland, and what we call Northern Ireland.
Methodist, I assume.
And in New England, it was what they called separatists, people who had left the Congregational church, and so they were called separatists. And they had essentially what we would call an independent Bible church, but they called themselves separatists. So they were conservative Christians, Protestant, and very numerous and growing, and they had ballot power, and they were not embarrassed about being very political and telling and sending. Back then, they sent remonstrances and memorials. Memorials was their word for petitions, and they sent petitions to their state capital. Because again, everything that was happening in religious liberty was happening at the state capital, not the federal capital. All right. So
good. And you said a couple of things. One is, first of all, will you leave that? Is that that copy of the book on the table there? Is that one that is not written in, not personal?
I'll get you one.
Okay.
Okay. For
All
your
right,
library here.
Somebody's asked me about it in the chat section, and I will settle up with you later. But if you'll get me one, that'll be great.
Yeah.
And you said that the heart of it is in chapter 1. Those findings are in chapter 1.
That's right. Yep.
Very good.
Yeah. I tell everyone, read chapter 1 first, and then just skip around.
Yeah.
For example, there's a chapter on Missouri. Did you know Missouri had an established church?
Wow.
It was French Catholicism. It was here for 80 years. 80 years. And then in April 1803, what happened? Louisiana Purchase. And in the stroke of a treaty, President Jefferson, signing on behalf of the United States that treaty, suddenly the French Catholic establishment was gone.
Wow.
Gone. Now what do? Because the territory is full of French Catholics. Interesting, huh? And Louisiana too. Of course, Louisiana, it was called the Louisiana Purchase, and then it was divided between the Louisiana Territory and the Missouri Territory. And the larger half was the Missouri Territory. So great stuff. There's a chapter on Louisiana and on Missouri. There's a really exciting chapter on Ohio. Why Ohio? Northwest Territory. Northwest Territory was, the Northwest Ordinance was adopted before the United States was a government. It was adopted under the old Articles of Confederation. And then the first state out of the Northwest Territory was Ohio. And it was settled by Puritans from New England just moving west. So what did those Puritans bring with? They brought them their state church. It's very interesting stuff.
Fascinating.
Very interesting stuff.
All right, well, let's make a transition, and let's just take one question from Pastor John Gilman. And he asked in the chat section here, well, let me just let you ask it, John. Do you want to unmute real quick? I'll help you. John?
Yeah, I was just, did all those original states have their own state religion? Was that a distinguishing trait of each state?
I'm not sure I heard the tail end of that question, but did all of the states have their state religion? 11 of the original 13 had state churches. Rhode Island and Pennsylvania did not. Rhode Island was, and the founder there was Roger Williams. It had nearly complete religious liberty from its founding. But the rest of the states thought that wouldn't work, and they they referred to Rhode Island as New England Sewer, or they referred to Rhode Island as Rogue Island, because they thought without a state church, moral discipline would simply break down.
Wow.
And then Pennsylvania, I think I already mentioned, never had a state church because Quakers didn't believe in a state church, but they absolutely believed in legislation that favored Quakers. Now, so the 14th state was Vermont. Vermont had a state church, the Puritan church. Maine, which was added in 1820, was carved out of Massachusetts, so Maine had a state church. The 15th state was Kentucky. Kentucky never had a state church. The 16th state was Tennessee. Tennessee never had a state church. But both Kentucky was influenced by Virginia, which had the Church of England, and Tennessee was influenced by North Carolina, which had the Church of England. So they were influenced. Florida had a Catholic establishment under Spain.
So would you say that any state that joined after the First Amendment was written did not have a state church if there was not one already in place? So no new states had a state church after that. Is that correct?
So we're dealing with 1791. That's when the First Amendment was ratified. So trying to think what states would have been added. See, in 1791, we only had 14 states. So yes, yes, that's true what you said about Kentucky and Tennessee, but it's not true about Maine. Maine had a congregational establishment and was added in 1820. And then immediately disestablished in 1820.
So it was a tension. All right, I got to transition.
It depends. I mean, yeah, Florida disestablished, not when it became a state, but when in a treaty we took the land from Spain. Missouri and Louisiana disestablished, not when they became states, but when we took the land from France.
Got it.
Okay.
All right,
I've got other questions about that, but I'm also curious about segment 3, so I'll let Rod transition us.
Yeah, let's transition, and then we'll stay on afterwards just for a minute and wrap that up. All right.
Well, so now we're all the way up to to March and April of this year, and I was going to mention 2 sort of contemporary issues. One is so the quarantine or stay in place, or the orders to do social distancing and to close your businesses unless you're an essential business and so on. What did that do to churches and our worship services? And as you know, because you've been following news maybe a little bit more than usual because we've been locked down, a few churches challenged in their states, or in a couple of cases their municipality, the lockdown order. I'll just call it a lockdown order. Because churches were not deemed essential services. Now, a few states or a few municipalities exempted out churches. So, of course, it was never a problem. But most lockdown orders, like the one here in Columbia, for example, said nothing about churches, but pretty clearly the lockdown applied to worship services because you couldn't gather unless it was, I don't know, originally was it 50 or less or 10 or less?
50 and then 10, yeah.
Yeah, so unless you had a relatively small worship service, you came within the order here in Columbia, though it never, I'm sure their lawyers said, let's not call out churches specifically, but nonetheless include them. for reasons of health and safety. So the Department of Justice, Federal Department of Justice, has come out and said, well, obviously there's a major health crisis, pandemic, et cetera, and so on. So it is constitutional because of the exigent circumstances for the lockdown orders in your jurisdiction to include assemblies that would be a church worship service. However, you cannot discriminate against churches in this sense. If you're closing what would be a worship, an in-person worship service, an auditorium, a sanctuary, then all similarly situated assemblies must also be closed, like a movie house, a concert theater, or concert auditorium, things of that sort. So the one that the Federal Department of Justice entered on the side of the church was a church in Mississippi, or no, sorry, South Carolina, Greenville, South Carolina, which is a very, very religious city. So it's a little surprising that this issue came up in Greenville, South Carolina. But a church there, the pastor arranged for cars to be in the church parking lot with their windows up, which this time of year, of course, is possible without being too warm. And they then could listen on their radio to what the pastor was saying, and the pastor was on an elevated platform down on one side of the parking area, and the cars were directed towards their pastor, so they could see their pastor and hear him on the radio. And the Department of Justice said, no, that's religious discrimination, because apparently just a block away was a Sonic. And the Sonic, because they serve their food and beverages outside, could be continue to be open and fully operable, serving people in their automobiles, and indeed with their windows open, because they had to open, of course, the side window in order to take in the food and beverage. So the key there is non-discrimination against similarly situated religious gatherings. But there is no, as some churches asserted, there is no absolute right to gather in worship in groups that create a health or safety problem. Now there's a sub-issue. The lawsuits haven't hit yet, but a church who did open maybe a worship service, maybe a Sunday school class for adults, or a Sunday school class for a large number of children, a youth group, if somebody caught the virus and was sick or perhaps even died as a result of exposure at the religious event, could the church be sued in tort? And they certainly could, for their negligence. And so the thing to do, if it works, if you can operate, the thing to do is follow the local and state directives in your jurisdiction, because then you've got that defense. Well, I followed all the law, and but nonetheless, I could gather, say, in a group of 8 for a Bible study, and then if somebody got sick out of that, you said, well, we did everything that the law said that was allowed. Now, there's 2 issues here. This is kind of for the lawyers. You see, the problem is causation. I mean, people get sick, but maybe you didn't get sick because you went to church. Maybe you got sick because you went to the grocery store or whatever. You're just jogging on a trail or walking in your neighborhood. But in fact, with current technology, we probably can figure out where you were exposed. And if you got sick and your only exposure was at church or at a Sunday school class or a Bible study, we're going to be able to do that with our iPhone technology. And who is near somebody else's iPhone that turns out to have the virus and so on. And you can also, your church can be sued, not necessarily for 100% liability, but 50% liability. For example, you might say, well, they didn't have to go to that worship service. We just held it, and those who wanted to come could come. Well, maybe they shouldn't have come because they were a diabetic or something, and therefore particularly vulnerable, or they were over 65. And so, but then a jury might very well say, well, that makes them 50% liable, but the church is still 50% liable. So I just send out there that please be careful and be mindful that there may be lawsuits, and they're not frivolous. And even if ultimately you won your lawsuit, you still would pay a heavy price in how that would disrupt your community and how that would hold up your church for disrepute, or at least disrepute in the eyes of some in your community, because you can bet that's going to be in the local papers and television station and so on, that a parishioner who got sick sued their church.
So what we want to protect is not just simply our religious freedom, but we also want to be mindful of the ways that we're putting ourselves at harm, not to mention the love your neighbor. That's obvious, I think. And but you're saying, hey, it's not the only variable is our religious liberty.
Yep. It's just like now we do criminal background checks on everybody who works in our nursery, and we all know why. We love the kids and we don't want them hurt, right?
Yeah.
But also we don't want to be sued. And you know, so be
okay, what about taking the government's money?
now this is a big topic, and even if you have no intent of applying under the payroll protection program, and it looks like there's going to be another 85 billion available under the payroll protection program.
Yep.
You should know that a number of religious organizations, some nationally known, I'm not going to name any, and churches, large churches and small churches, have applied for and received federal money under the payroll protection program, which I'm sure you know, technically it's a loan through the Small Business Administration. But if you administer the money, if you steer it towards payment of salary, payroll, then it becomes a grant. In other words, the loan is forgiven. And anybody who's halfway bright, they're going to use the money to meet their payroll, and money that they normally would use for payroll, they're going to use for other purposes or simply keep it in savings. So of course, these loans are going to become gifts, outright gifts. Now, there's a theological issue there. And we're going to probably have some differences of opinion on whether this is prudent and consistent with the Bible. But even if you, whatever your biblical position is, your friends and colleagues and other Protestants and Catholics are taking this money. So, and I'm saying this, truncating it, there are strings attached. And the administration, through administrative rulings, are trying to cut the strings. And a number of strings have been cut. I'm involved with a network of lawyers nationwide that's working on this issue. Some of them are general counsels for big religious organizations. Again, I'm not going to name any. And some are lawyers for denominations. And so the administration has responded by cutting some of the strings, saying, well, we're not going to apply this to a religious organization because of your First Amendment rights or because of the Religious Freedom Restoration Act or both, and so on and so on. But not all the strings are cut. And so I'm going to mention three, I guess. One is there's some federal civil rights statutes which require non-discrimination in employment. Now, none of them are LGBT. The second string is there are federal non-discrimination statutes that require non-discrimination if you receive federal funding, and this is federal funding, in how you serve people. So it's not as to employment, but it's how you serve people.
Churches, an example would be
what you teach in Sunday school.
Okay.
Men's Bible study, children's church, children's Sunday school, youth group. That's all service to people.
Okay.
And so it's non-discrimination in how you serve. And then the third string, which we haven't been able to cut, is if the money you receive from this program and other federal programs, if you're participating in other federal programs, if it exceeds more than $750,000 annually, then you're subject to audit. And the audit is mandatory. It's not that they have a right to, they think somebody is embezzling and then so they come in and audit you. There's that right too. I mean, you can't get government money, but if you spend the money illegally, you're going to be audited, and you should be. But this is a mandatory audit. I mean, you just have to go do it, and then you turn over the results to the OMB, Office of Management and Budget. You file it with them because they're the ones that require it. $750,000. You say, well, that's not a problem. The money I got, I'm a small organization. Maybe I have 8 people and I got $250,000. Okay. Well, then you're not subject to this audit. But again, it's over $750,000 a year. And the audit is not just how you spent these federal funds. It's the audit of your entire books, wall to wall. And because they think you might move money around, which people are doing bad things, do move money around, right? And they can audit how you spent the money, not just where you spent it, but, all right, so you had so much money allocated to a men's day-long conference. Well, tell me about that conference. Who was your speaker? What did he or she say? What went on? How much did you pay them to fly here? What was the honorarium? It gets a little bit intrusive. We're trying to get that requirement stopped, or we're trying to get OMB to say, well, it's only for those who get 5 million or more a year or something, which again would give most of us a break. Now, let me go back to non-discrimination. You say, well, that's not a problem. I don't discriminate on the basis of race and national origin and age or sex, and I believe that to be true. Although, I mean, we might teach differentiation of the sexes. We might teach that God made men and women differently with different needs and different, normative ways of dealing with problems or responding to scripture, which is why we have men's studies and women's studies, because we differentiate. And all of a sudden now, so if you were to keep a man out of a woman's book study, now you're discriminating on the basis of sex. And here's the big one, because you might say, well, if a man wants in that women's book study, let him in, both the men and women might benefit. But disability. For example, you may be a small startup church. You're in a 75-year-old building, 2 stories, and guess what? It has no ramp. Well, you say, I'll build a ramp, right? I'll have a weekend project and we'll get that ramp built for free so the wheelchairs can get in. But you know what you can't do for $2,000 and a weekend work crew? you can't put in an elevator so that the wheelchair can get to the second floor. And now you're out of compliance because you're discriminating on the basis of disability in how you serve people.
All right, let me jump in. We got to bring this to a close. So I think we're picking up what you're laying down, but I want to walk through a few things with you. First of all, you're saying that we're hoping that some strings get cut, but they're not all get cut. I do want to ask you quickly: have the organizations that you're working with that are unnamed already applied for the money and are receiving the money and now cutting the strings, or are they waiting primarily until the strings get cut before they apply?
Several organizations that I know of have already received the money. And in fact, they're applying it to payroll.
Okay.
And so technically, not technically, they've agreed to these strings, whether they knew it or not.
Right.
Now, but if we can get the string cut, it works retroactive.
Okay. Next, are you, if you're an elder of one of these churches like your own, and you're sitting in that meeting, I'm hearing you say, you're going to say the pastors, let's not go there unless we absolutely have to, or heck no, we'll never participate if I have anything to do with it.
Well, to me, it's a theological question, certainly. I mean, how do you read Scripture? And you might say, especially if Scripture teaches, well, be wise, be prudent, but now you have to contextualize that. So it's a matter of acting with good judgment.
But you're getting me back to the Trinity Lutheran Church issue, and so I kind of get the Espinoza because that's a school that her children attend, and she's a single mom. But the Trinity Lutheran case, make that category distinction for me as to why you, quote unquote, celebrated that, but this one you're more hesitant with.
Well, in the case of Trinity Lutheran Church, it was a grant, an out-and-out cash grant,
okay,
under the Missouri Department of Natural Resources, and there were no strings other than you had to use the grant monies to use old tires, which were then destroyed, and put that down on your playground. Those were the only strings. In other words, you had to use the money for the grant purpose and for no other, but there were no other strings.
Got it. So your criteria then, Carl, is you're always thinking through what are the strings, what are the strings, what are the strings. Am I correct that there was two parts of this, and one was the PPE and then the other was a CARES Act? And I don't understand the difference of those, but I assume they're both wrapped into one thing. They were just two different purposes.
The CARES Act was the name Congress gave the full 2.2 trillion. Of the 2.2 trillion, 350 billion was the PPP, the Payroll Protection Program.
Got it.
There was another, I think, I may have this number wrong, another 80 billion for what was called the Economic Injury Disaster Loans. And that was loans, one-time loans, up to $25,000, no more. And it was a loan, not to be forgiven, but it was a low interest loan, a 1% interest, and it's to be paid off over a couple of years to your local banker, because both loans are through, the SBA works through your local banker.
Mm-hmm. Gotcha.
And the strings are somewhat different under the Economic Injury Disaster Loans Act, a portion of CARES. And I should say, because it's only 25,000, that's the maximum. A lot of groups said that's not worth going after. 25,000 to take on potential strings, it's just not worth it. 25,000. 25,000 is not going to keep my doors open. You hear me? I mean, even a small church can't keep their doors open on 25,000.
Right. Well, TEI was encouraged to apply for the CARES Act portion, as I understood it, by a well-intentioned former banker. And the essence of it was, well, you get 10,000 as free money, et cetera. And I was unwilling to think about it until I had a conversation with you about it. And I think you're answering my question.
Okay, but everything you say is right except the name you gave it. The CARES Act is the big umbrella. That's 2.2 trillion. Under the CARES Act is PPP, which is big money.
Okay.
You might get $1 million there. And then I have to keep looking at it because I can't remember. The economic injury disaster loans, that's only 25,000 max per unit. And most groups, even little groups, said, hey, 25,000 is not worth it.
But all the but all the strings that you mentioned that are
Yes.
concerning are still attached.
Yeah, pretty much.
Okay.
Not the audit, but the non-discrimination strings, yes.
We got to wrap this up, but I know there's several questions, and we are also doing another podcast after this, so I can't let us stay on more than about 3 to 4 more minutes. But Dan has a question, so Dan, if you'll unmute yourself, I'll let you ask Carl, and then whoever else. Go.
Yeah, thanks. I was just wanting to clarify if those SBA funds that are received are put into savings or they're not immediately used for payroll, do the strings that you mentioned still apply?
Oh, yeah, absolutely. And
Right.
I think
Okay. Regardless of the
yeah, not only do the strings apply, but I think you're violating the loan. The loan, you have to use the loan money, the SBA loan money, which comes through your local bank. You have to use it for certain designated purposes. The number one purpose is payroll, but you can also use it for utilities. If you rent a facility, you can use it for rent. If you have a mortgage, you can use it for the interest on the mortgage, but not the principal. But you've got to use it for those reasons. If you just put it into savings, you're in trouble.
I see.
Carl, you can only use 25% of the money for anything other than payroll. 75% has to go to payroll.
Yeah, I thought it was 70, but whatever, 70 or 75, yes.
Carl, what advice would you give if there's a pastor or church who's hearing your concerns and they've already made application? What would you tell them to do beyond prayer and hoping that you and your lawyer friends are successful?
Well, the banker and their lawyer, if they have one, should tell them, well, the strings don't attach yet just because you've applied. The strings attached when the money goes from your banker to your account. So when the money is transferred, that's when the strings attach.
Okay.
And once the money is gone, then the strings are gone. So if you're able, let's say you get $500,000 and you're able to spend that $500,000 on payroll over the next couple of months, then once the money's gone, the strings stop.
Okay, well, that's helpful. Gotcha.
You know, some groups are saying, look, if I don't take this money, I'm going to have to close. And I have a ministry. And I think if I can just make it through this rough spot, I can keep the ministry going. And I think the God's in this ministry. So they're saying, I'm willing to take a risk for a few months and then I'm out from under. And they're right. Now, you know, if bad things happen during that period, then you're not out from under.
Okay. Wow. You never failed to disappoint, Carl, whether we're in private conversation over coffee as I lean over you while you're working, or in your webinars with us. This has been fascinating, and I want to do it again before long. In fact, on a regular basis, I think there's a lot of interest in you helping us keep current on this religious freedom. And like I said before, I know that you represent the ways in which sometimes there are state issues that come up that you wish more people were excited about. The one on campus, for instance, related to the student ministries that we've worked on. These kinds of things can be oblivious, but if we all lose, if one person loses on these religious freedom, we all lose. And if one person continues to maintain all the issues of the First Amendment, then we all win for the reasons that you mentioned, our religious zeal and the ways in which we want the proclamation of the gospel to go forward. I'll give you the last word before we have to shut this down and let Marshall Robb there take your place for our podcast. But yeah, thank you for serving us today.
Well, thank you, Rod. The TEI is a real gem and a precious resource that most communities don't have. In fact, I don't know where TEI is replicated anywhere else. Probably you do, Rod, and maybe you've managed to do plants elsewhere who wanted to replicate what you do here. But it's a precious resource. I take advantage of the library here and the kind of tapes like Mars Hill that you subscribe to, and you know, it's a real pleasure, and happy to do it again. And we can work out a date.
Let's do it. Well, thank you for your kind words and also your financial support. So everybody go over to the donate page at teimissouri.org. Although we're in really good shape, so God's blessed us. So thanks a lot, everybody. Anybody have a final word? Just a word of thanks to Carl. I'll let you unmute yourself and just say a quick one sentence blessing to him.
Just many, many thanks, Carl. That was great.
Yeah, and thank you, Carl, for today. And then also, I think your book's a good gift to our society. So I'm looking forward to reading some of that.
Great.
All right, everybody else can give a reaction with a hand clap or a thumbs up, huh? There you go. All right, well, we did pretty good on Zoom. I think we're all becoming experts, so well done. And just leave everything up there, Carl, because Marshall Robb will come in behind you. If anybody's just looking to waste time, we're going to talk about youth culture with Marshall Robb there with Craig Kidder and the Qualifiers podcast. So, all right, blessings, everybody.
Likewise. Thank you.
Good to see you, Dan. Take care.
You too.
Thanks for joining us there, Ron.
Thank you.
Hey, Shirley. Good to see your face today. Deanna, Todd, Heather. How you doing, Heather? Unmute yourself there, Heather. Where is she?
There we go.
Hey, how are you? You doing good?
Good. Yes, we are.
Oh, that's great. Thanks for sitting in today.
Yes, thank you. Great.
All right, very good. Okay. So long, everybody.
Bye.
Thank you.